We're going to be talking about the pandemic and providing an update for employers on the impact of this pandemic on U.S. immigration processes and policies. I'm Amy Royalty, and I'm joined today by Marcia Mabunko. We are immigration attorneys with Ryan Swanson in Cleveland. Our presentation today will be around 30 minutes, and we're going to follow it with a question and answer session. You can actually use the Q&A box to submit your questions throughout the webinar, and you can find that on the bottom of your screen. A recording of this webinar will be available on the website after the program if you would like to share it with colleagues. Note that all lines are muted. We will answer as many questions as time allows at the conclusion of the webinar. If we're unable to answer your questions today, we will follow up with you after the program. We will also email our presentation slides with you after the webinar. Thanks again for joining us today, and we will jump right in. So as you all know, coronavirus is upending a lot of US businesses, and it raises a host of difficult immigration issues for US employers, including the status of H-1B visa holders, international students, obtaining I-9 verification for new employees, and travel restrictions that limit mobility for international personnel. Below, we want to talk about some of the important immigration issues facing US employers and your foreign national employees during this current public health crisis. So we're going to cover these slides kind of by agency and then also types of visas and processes and how your employees and workforce as well as your business can be impacted. First, I want to talk about Department of Labor and the impact especially on H-1B and E-3 employees. As you know, these visa petitions are regulated both by the Department of Labor and US Immigration, Citizenship and Immigration Services. So the main thing you want to keep in mind is that for H-1B and E-3 employees, the work location as well as the wage paid and hours worked is very important in terms of ensuring that these employees are maintaining their H-1B and E-3 status. So if there is an office closure, if your company has to, close offices, as has happened for many non-essential businesses in Washington State, then this could impact any of your employees in H-1B or E-3 status. In addition, if you have a job location change, so for instance, if your office closes and you have these employees working from home, then that could impact their H-1B status. And you want to be sure that you're taking the necessary steps to maintain their H-1B status. So the good news is that if the employee's home is within the normal commuting distance of your office or the office that's listed on the H-1B petition, as well as the LCA that's submitted with the Department of Labor for that petition, which is basically within 50 miles or within the same metropolitan statistical area, then you just need to post a notice at that office or new work location, which would be their home, in 2 conspicuous locations. You would not need to file an amended H-1B petition in this situation. So this is very helpful as long as they're within that normal commuting distance. For King County, Seattle, Bellevue, Redmond are all within normal commuting distance, as well as Pierce County and Snohomish County. Those are all within the same metropolitan statistical area. I still recommend that you check with your immigration attorney who handled the H-1B petition, or reach out to one of the attorneys at Ryan Swanson just to confirm that none of your employees would require an amended H-1B petition as a result of their working from a home office. So when would you need an amended H-1B or E-3 petition? Basically, a few different situations. Anytime where the employee is working at a home office that's not within normal commuting distance. And again, this is any period of time that's more than 10 consecutive business days. If they will be working from home, that LCA posting needs to be done at their home office, but they would not require an amended H-1B petition. Also, any material change to the H-1B or E-3 employee's employment. So that would be any change in hours. If you reduce an employee's hours from full-time schedule to a part-time schedule, then you would need to file an amended H-1B or E-3 petition for that employee. Any type of reduction of wage or scope of work that they're working on would also potentially require an amended petition. And that petition needs to be filed before that change happens. So be sure that you consult with Immigration Counsel prior to making any of these decisions or changes that could impact your employees in H-1B or E-3 status. So we'll talk about, I think a lot of employers and companies are already considering whether they can put, employees on some type of temporary furlough or unpaid leave of absence. And unfortunately, that could have a significant impact on your H-1B or E-3 employees, because that would be considered benching. This is because when an employer sponsors an H-1B or E-3 employee and files the LCA with the U.S. Department of Labor, it certifies that you'll pay the professional at or above the required wage. And you're also required to pay that non-immigrant the required wage for any time in non-productive status due to the decision of the employer. As a result, any temporary layoff or furlough is generally not permissible for the H-1B or E-3 employees, as that would be considered benching. And it could subject you to substantial penalties, including back wage payments, fines, and potentially debarment from the H-1B program. So you just want to be very careful before making those decisions, and definitely consult with your Immigration Counsel regarding the options, because otherwise you could be subject to payment of those back wages. If you do need to lay off or terminate employment for an H-1B or E-3 employee, that termination must be bona fide. What that means is that you are required to provide the agency notice, that means notifying U.S. Citizenship and Immigration Services with which you filed the H-1B petition. And then also you must withdraw the LCA that was submitted with the Department of Labor for that employee for that position. Only then, if you have complete that bona fide termination, can you avoid that liability for payment of back wages. You also need to offer to pay that cost of return transportation to their home country. And that offer usually we recommend that offer is made in writing, in some type of separation or termination letter or agreement. And then if the employee waives that offer of payment, they can sign that they have waived that offer, that they do not want to accept that payment. The good news here is that employees in E3 and H-1B status do have a 60-day grace period. That allows them to stay in the United States, transfer their H-1B status to another employer, which means they could try to secure another job and find another H-1B sponsor for them. And as long as that H-1B transfer is filed within the 60-day grace period, they can maintain their H-1B status. And they'll also, if they can't either change their status or transfer their H-1B status, they would be required to depart from the United States at that time.
And this is Marcia. I just wanted to make one additional comment in terms of businesses that may be continuing to hire at this time. Given that we don't know how long the stay-at-home orders will be in place, or how long an individual business may decide to extend the work from home or remote option to employees. If you are engaging in hiring, it's a good rule of thumb to notify the Immigration Counsel that we will be offering this remote option to this employee moving forward for an extended period of time for this new employee, and adding that work from home, that home office location on the LCA from the get-go. So just make sure to bring that issue up and let counsel know if that is going to be an extended period of time, and you may want to consider that for new hires.
So yeah, in addition to posting the notice at the employee's home office, we also recommend that you document the public access file with evidence that you do have that remote work policy, or that the office is currently closed due to the governor's order. So that will help show that you're in full compliance and with the H-1B regulations during that period. Okay, so now we'll talk about labor certification. One other thing on H-1Bs, a lot of employers are concerned about, the situation where they have to have a layoff or termination, and what can they do to support your employees in that situation. definitely, again, recommend consulting with us. We can assist with a B2 change of status application to at least buy them some time and allow them to stay in the United States while a visitor, change of status to visitor status is pending. We can also offer to do, a 30-minute consultation just to talk to the employee about their options. And, a lot of employees right now are very scared about travel in light of the virus. And they're also, in some cases, for instance, with, if they're from India, they're unable to return to their home country. So it's really important that, they have all the information needed about their options and consult with Immigration Counsel about any options. Unfortunately, at this point, there's no special guidance. The Immigration Service and Department of Labor have not issued any guidance that says, an employee can stay in the United States beyond their authorized period of stay or after the 60-day grace period ends due to the extraordinary circumstance of, termination of employment due to the pandemic. So hopeful, and I know that the Immigration Lawyers Association is trying to work on, getting some type of guidance or more forgiveness or exceptions to the current rules, which are pretty strict about unlawful presence and overstaying your status in the US. So, but you can definitely, help ease the pain and, by at least you could offer that consultation or the potential change of status or other options for them. So now we'll talk just briefly about labor, Department of Labor PERM labor certifications. So unfortunately, the Department of Labor has not stated that, that employers, that they're still requiring the posting of a physical notice of filing at the employer's worksite, which is one of the recruitment steps that's required in order to sponsor the employee for a PERM labor certification. There's no exception to that physical posting requirement right now, which we're hopeful again that something will change. The Department of Labor will have some new guidance, but as of yet, that posting still needs to happen at the physical office for 10 consecutive business days. If the office is closed, we are recommending that employers delay that posting. The good news is that it's only a 10-day posting, and then the company has to wait 30 days to file the PERM after the 10-day period ends. So it shouldn't delay the PERM labor certification by, a significant period of time, depending on how long the office is closed. So for now, that's what we're recommending. And then the other thing that employers need to keep in mind is that any type of layoff could impact the ability of your company to sponsor an employee for a labor certification. And this is because if a layoff has occurred within 6 months prior to filing a PERM application, the employer is required to notify all potentially qualified laid-off workers of the job opportunity and consider them for the position. And this only applies where the position is in a substantially comparable position. So basically the same or similar occupation or position for which the employer is wanting to file the PERM application. So before you contemplate or move forward with layoffs, and this is for any employees, whether it's foreign national or US employees, you need to take a look at whether this might impact any future PERM applications that you want to file on behalf of your employees. And this could have a significant impact on any employees who are reaching the final limit of their H-1B or L-1 status, because a lot of times you have a strict, deadline of getting that PERM application filed by the end of their 5 years in H-1B status. Or in some cases, trying to secure approval of the I-140 petition before they reach that 6-year maximum of H-1B status. And one thing I forgot to mention again on H-1Bs is that unlike the PERM applications, Department of Labor is allowing employers to do electronic or intranet posting of the LCA. So the good news is you can meet full compliance with that LCA posting requirement, even if your physical office is closed, as long as you can post it conspicuously via some type of electronic means, electronic posting, or like a company homepage or intranet page, so that employees would have access to that notice. Okay, so I think we covered the labor certification, most of the Department of Labor sort of impacts and changes. And again, feel free to ask questions if you have any about this. And now I want to talk a little bit about U.S. Citizenship and Immigration Services. So we have had a lot of changes in USCIS processing, and we anticipate that that will continue. For now, what we know is that premium processing has been suspended for all non-immigrant petitions. Actually, it's suspended for all I-140 petitions as well. So that includes H-1Bs, H-1B extensions, transfers, change of status, any type of non-immigrant and immigrant petitions filed with USCIS. Do not have premium processing. So for H-1B CAP petitions, USCIS did make an announcement that it will resume premium processing for the H-1B CAP petitions on May 27th. That's for any petitions filed with a change of status request. And then June 29th, or possibly sooner, for any petitions filed with the request to notify the consulate of the approval. So we haven't heard of any change to that policy that impacts the H-1B CAP petitions. As you may know, USCIS did just complete the registration process for H-1B CAP petitions, and the filing window is now starting between that period of April 1st and July 30th, or sorry, June 30th, 2020. So we haven't, again, that hasn't changed. That 90-day filing window is still in effect. So we also would just caution everyone to expect delays in processing. So that's of all petitions, non-immigrant, immigrant petitions, adjustment of status, green card applications, which were taking maybe 5 years ago or a few years ago, 6 months to process. We're anticipating that now it will be closer to 18 to 24 months to process an adjustment of status application. So for this reason, we recommend filing any petitions, especially your extensions. So H-1B extensions, L1 extensions, TNs, EAD, AP renewals for people who have, an EAD, if they're working on an EAD pursuant to an H-4, their H-4 status, or an adjustment of status application. You want to file those at least 6 months prior to expiration. And then the important thing to note is that employees, where you file those non-immigrant petitions or extensions, the employee will be eligible for an automatic 240-day extension of their work authorization and status while their extension is pending. So the sooner you file, you can make sure that you don't max out that 240-day automatic extension period. USCIS has also stated that it is going to provide an additional 60 days during which you can submit a response to a request for evidence if the request for evidence was issued between March 1st and May 1st, 2020. So that will allow employers and individuals an additional 60 days to submit responses to those requests for evidence, which is helpful. One other thing USCIS has stated, and we didn't put this on the slide, but they are allowing for electronic signatures of petitions, which is very helpful, especially for all of our HR folks and employers working from home, as well as ourselves. The one thing to note is this is not the same as electronic signature. So we can't rely on DocuSign or electronic signatures for those petitions. It does need to be a photocopy or scan of a wet signature. And if you do that, make sure you keep the original signed document in the file, because USCIS could request it at a later date. Just note that, if an individual in non-immigrant status, such as E3 or H-1B, L1 or TN, if they overstay their status, right now they could be subject to trigger a bar for unlawful presence, and there's no exception to that right now. So you just want to be sure that all employees are well informed that they do need to depart the US prior to accruing any potential unlawful presence. Okay, one more. So another thing that has happened recently is that USCIS has closed all of their offices. That includes offices where physical appointments are completed. That includes application support centers and field offices where they conduct their green card and naturalization interviews. They are closed until at least April 7th. We anticipate this closure could be extended So we will be sure to notify employers if that happens, but for now, all of the offices are closed until at least April 7th. And what we are receiving some cancellation notices for AOS and naturalization interviews and biometrics appointments. We are also receiving notices that they're waiving biometrics in some cases where they say they can reuse biometrics. Some of these seem to be faulty notices, so be sure to check with your immigration counsel first before relying on, a notice like that. But for now, you don't need to go to any appointments. There are no appointments available at the local offices. Like I said earlier, we also would, expect delays in processing those adjustment and naturalization applications. And we anticipate the processing time could be as long as 2 years at this point. It was closer to 12 to 15 months, and now we're anticipating it will be closer to 18 to 24 months and possibly longer. Also, for adjustment of status applications, and this is all adjustment of status, whether it's employment-based or family-based, we have to submit the new form I-944. That is to comply with the public charge rule. And that is a very, very burdensome application. It requires substantial documentation to show that the applicant will not become a public charge. So just a heads up that these applications take longer to prepare. And then of course, with everyone working from home and getting the signatures, it could take longer to get these applications prepared and filed, and just want you to be aware of that possibility.
Yeah, and a couple notes I was thinking as we were talking about this, the information we've received from CIS and DOL is that they're operational right now. Now, I think that may be true, but just like the rest of us, there are going to be some effects that are inevitable. People who are ill that work for these organizations, these agencies, or people that are now working from home. And I think that all will trickle down into these longer processing times that Amy mentioned. And then of course, there's the effect of the CIS office closures. As we see now, we're at about 3 weeks of CIS office closures, at least April 7th, being the anticipated end date to that. But all those interviews, those biometrics appointments, those all will need to be rescheduled, which will clearly back up any other cases in the pipeline to be scheduled. So we won't know the true impact until we get back to business as usual and operational. And at that time, we'll be able to sort of assess how much of a backup that will cause. The other thing to keep in mind with hiring and transfers, traditionally with most H-1B cases, particularly maybe more complex cases or ones that have more difficult facts involved, we might have suggested wait for an approval to come through, file with premium, don't have an employee notify their employers until we know the approval has come through. Things have been a little more difficult under this administration, and so that's been our sort of conservative, cautious advice. With premium processing being suspended and longer processing times, businesses will need to make that difficult decision in the hiring process and consult closely with immigration counsel as to whether or not they should even proceed forward with an H-1B transfer. Normally, once a case is filed and received by immigration, H-1B portability will come into play, and they can technically begin working with an employer. But again, you'll have to make those sort of internal and strategic decisions on whether it makes sense to proceed. If it is a more complex or a weaker H-1B case, that'll be a conversation you'll have with, hopefully with immigration counsel as to whether it makes sense to proceed forward with that hire.
That's right. And also just to reassure, our clients and potential clients, we are fully operable working from home. Our office has taken a number of steps to ensure that we are able to prepare and complete all of the immigration filings for our clients while working from home. And the nice thing is we have that benefit of being able to rely on the electronic signatures. So we're hopeful that that won't have a significant impact on, in terms of our processing and preparation and filing. And so far, so good. I feel we've really done a great job coming together and figuring out ways to make sure that we are able to support our clients during this period. Just a heads up on the H-1B petitions, the receipt notice, because now we have to wait for that physical receipt notice as opposed to allowing the employee to start working based on the email notification of receipt when we file with premium processing. That can take, let's say, 2 to 4 weeks from filing. So again, just giving recruiters and your candidates a heads up that, you know, it might be a longer period of time before they can actually start working for the company, even if they start working based on that receipt notice.
Great. So moving on to Department of State, we're looking at the impact of the COVID-19 pandemic on U.S. embassies and consulates. Currently, as of March 20th, all embassies and consulates have canceled all routine immigrant and non-immigrant visa appointments. And, you know, it was sort of a trickle effect. We started seeing some different posts implementing different requirements, but as of that March 20th date, it is posted on the Department of State website. Only emergency visa services are being provided at this time, so the post may not be closed. And emergency services are generally going to include services to U.S. citizens, not including things like a routine passport renewal, but if there is some sort of an emergency situation where a passport's required life or death situation that requires it, that would be an option. It may also be if there was any sort of security issues going on in that country or any other emergency services, probably more geared towards U.S. citizens and permanent residents that are living abroad or that need to travel. So keep that in mind. In terms of tips for employees who are in the United States, keep in mind for your employees who might routinely rely on going for visa appointments to extend their status. So your E3s or individuals who are working under the L1 blanket who traditionally would go book an appointment and extend their status through that manner. You'll want to keep a close eye on those, and you may need to opt to file with USCIS within the United States versus travel. We're also dealing with a number of restrictions when it comes to travel, which would make it difficult anyway in terms of different country quarantine restrictions. For example, I know that we had a couple of clients who had traveled to Australia to renew their E3s, and then upon arrival were told you can't even come into the consulate because there's a 14-day quarantine restriction. And that was earlier on in the pandemic. Now, of course, they've canceled all appointments, but those different quarantine restrictions may still exist. And then different countries may have country-specific requirements as well in terms of quarantines or restrictions. We had a client in Israel who notified us that because of the quarantine restrictions in Israel itself, the embassy and the consulate were subject to different restrictions as well. So keep those things in mind, and we will go into the overall travel restrictions as well in just a moment. So I-9, that was definitely a question we were receiving pretty early on in this pandemic in terms of what do we do if we as a business have chosen to operate solely remotely. And earlier on, before it became mandated in different states, there was not a lot of guidance from the government, and we were advising employers to use authorized agents for sort of the remote work employee guidance as a guiding point at that point. But luckily, the government has given us some interim I-9 guidance. And this does defer the physical presence inspection requirements for Section 2 of Form I-9. So as a reminder, when you do hire a new employee, they do need to complete and have their work and identity documents verified normally in person within the first 3 days of working for remuneration. In this instance, because of the fact that most offices are closed, and depending on what state you are, that's mandated by the governor, the government has provided guidance that you can actually inspect those Section 2 documents remotely. And their examples are video link, fax, email. You still need to comply with that 3-day rule. It's just that you can inspect that, so you could do a Skype call or a Zoom call and review those documents or have them email it. And then you will still obtain, inspect, and retain those copies of the documents within those first 3 business days of an individual starting work. However, that doesn't take away from the requirement to complete Section 2 in person and within 3 business days of the conclusion of this interim policy. And at this point, that policy was enacted on March 20th, and it is set to go through May 19th, so a 60-day period, or upon termination of the national emergency if we are lucky and this all sort of is concluded earlier than May 19th, then whichever comes first would be when that policy ends, and you would be required to do that in-person inspection. So once you've completed the virtual review of the I-9 documents, you can go ahead and have that employee start working as usual. But once business operations are back to normal and you are back in person in the office, you do need to complete an inspection of those Section 2 documents. The government gave us specific language that you would input in Section 2, the additional information field, which would confirm that the documents have been physically examined, and you would enter COVID-19 as the reason for the delay in that physical inspection. One thing to note in terms of this interim policy, if you have an office in an area where employees are still going into the office, that would not then permit this virtual inspection policy rule to apply. So you would then need to do an in-person inspection of those documents. But for locations where employees are working remotely, business operations are shut down, everything is work from home, you could use this policy, and you would want to attach a memo, which is something that we frequently recommend anyway for sort of unusual I-9 circumstances, but it would document your specific telecommute and remote work onboarding policy during this specific and unusual time. And we would recommend that you attach that memo to any I-9 that's inspected through this virtual inspection option during this time. So that is it for the I-9 guidance. If anything else is added to that, of course, we'll continue to update you. All of our guidance throughout this presentation, it's an ever-evolving sort of scenario. So we may get updates, we may have new guidance, and our goal is to kind of keep you in the loop and hopefully provide another presentation with any new and updated guidance in the future. So moving on to travel restrictions, there were a number of travel restrictions that came out through a series of presidential proclamations. You'll see in the slide here sort of a timeline that we've listed out, starting from the initial one, which went into effect on February 2nd, suspending entry for aliens who are physically present in China within the preceding 14 days. And then after that initial one, we saw another series of restrictions. March 2nd, this also was extended to include Iran. March 13th, that was also extended to include aliens physically present in the Schengen area within the preceding 14 days. And then finally on the 16th, we saw the suspension of entry for aliens who were present in the UK or Ireland. And these restrictions did have some exceptions in terms of who could still come in, including some exceptions would include foreign diplomats, of course, US citizens or lawful permanent residents, certain family members of US citizens or lawful permanent residents like spouses, children under the age of 21, sometimes parents if it's a US citizen. And there were also some exceptions for air and sea crew traveling to the US and for certain specific visa categories. In terms of traveling into the United States on a work visa, we've had, I know I've had at least a couple individuals come in on work visas, at least in the early part of this travel restriction, these presidential proclamations. So our understanding is that should still be an option. However, keep in mind if they're traveling from any of these specific restricted areas, any inbound flights to the United States would be subject to being routed to specific airports that have particular health protocols, health screening protocols that have been implemented. So there were initially 11 airports that were designated for that, and there might be a few more now. So those were the presidential proclamations, and then separately we had the travel restrictions. There was an agreement between Canada, Mexico, US, or the NAFTA countries in terms of travel restrictions here in North America. And the US has decided to limit inbound land border crossings from Canada and Mexico to only essential travel. And this will cover a period of March 21st through April 20th. Of course, any of these dates are subject to change and extension. Canada also came out last week with a implementation of a 14-day mandatory quarantine for everyone entering Canada except for essential workers, some of whom they've defined as truck drivers and healthcare workers. However, essential travel in general under this restriction does include travel of US citizens and lawful permanent residents who are returning to the United States, individuals traveling for medical treatment or to attend school, work in the US. So again, we recently had somebody on a TN that was able to successfully fly into the United States. And also different emergency responders and people coming in for public health purposes, as well as lawful cross-border trade, again, trucking, movement of cargo, and then official government or diplomatic travel, and US armed forces and their spouses or children, or any other military-related travel. What would be considered non-essential travel? I think we can generally conclude that travel for tourism, such as sightseeing, travel. So that is our travel restrictions from the presidential proclamations to NAFTA. Again, these are ever changing and the restrictions could tighten up again and we could see more restrictions, but at this time, this is the most current information we have.
And just jumping in, Marcia, you've heard that they are processing border L1s. So at least at the airports, they're processing L1 and TN petitions submitted at the port of entry.
Right. So the last update we had was that they were still processing Ls, intermittent Ls, and as well as TNs. So that again could be subject to change, but at this time we are seeing those particular applications processed at the border.
Okay. Okay. So am I talking about F1?
You are, yes.
Yeah. Okay, so if anyone has any questions, I know we're running a little over, so we'll try to kind of just go through these next slides a little bit quicker. But if you do have questions, feel free to post it using that Q&A box at the bottom of your screen. Or again, you can send a follow-up email or contact us after the webinar, and we're happy to answer any questions. So, so the impact on students in F1 status of this COVID-19, ICE, or Immigration and Customs Enforcement, which regulates student visas and the SEVIS program, did issue interim guidelines, which is helpful for students. So ICE has said that if school closes, the F1 students should remain in active status in SEVIS as long as the students intend to resume their course of study when classes resume. And basically this just lists the 3 different scenarios that will allow their students to maintain their F1 status even if, let's say, the whole school is closed and not allowing any in-person classes. The second situation would be if a school closes temporarily but offers online or alternative learning options, the F1 students should participate in that online or other alternate learning options to make sure that they remain in active F1 status. And then the third situation is if a school closes temporarily but offers online instruction or other alternative learning procedures, non-immigrant students should participate in online or other alternate learning procedures to make sure that they're maintaining their active status. So that's similar. I'm not sure the difference, but basically if there's any online learning available to students, that those F1 students, to make sure they're maintaining their status, need to participate in that online learning program. Universities and colleges have a lot of leeway for procedural adaptation. So really all students should check with the DSO at their school to make sure that they are in full compliance and that they're able to maintain their F1 status despite any type of school closure or change from physical classes to online learning. And the most important thing is that the SEVIS, the school needs to update SEVIS within 10 days of any change in the student status. So if they move from the physical classes to online learning, that notification needs to go to SEVIS. So let's see, let's talk a little bit about OPT, students in OPT and CPT. I don't know if we have a slide on that. Let's go to the next slide.
I don't think so. Yeah,
no,
next
so just a note that there's been no changes there. So students on OPT are permitted to have a total of, I always forget this, I think it's 90 days of unemployment. So if the student is unemployed for a period of more than 90 days, and that's not consecutively, that's as a whole, during that 1 year of OPT employment, they could be found to be in violation or not maintaining their F1 status. So that could be an impact. And then if the student is on a STEM extension, they're allowed an additional 60 days of unemployment. So that's just one thing to keep in mind. And there have been no changes to that rule on unemployment for students working on an OPT or STEM extension. So I see just a question here. I'm just going to answer it quickly. Is do you have any ideas as to when premium processing for H-1Bs might resume for CAP exempt employers? And I haven't heard of any different treatment, I guess, of a CAP subject versus CAP exempt employers. Have you, Marcia?
No, I think that the premium processing is suspended across the board.
Yeah, so it's suspended for all H-1B petitions, and I haven't heard of any idea or any date as to when USCIS anticipates resuming premium processing for those CAP exempt employers. For the CAP subject petitions, again, we anticipate, based on the current guidance, that it would resume in around late May or late June, depending on the type of petition.
Right. Yeah.
Okay.
And a reminder for individuals who have students who are working on their OPT EAD, they should still continue, if they are STEM eligible, please remember to encourage your student employees to file that STEM extension as early as possible, which is generally 90 days in advance of that OPT EAD expiration, and must be filed before it expires in order to be eligible for STEM. And that is a good safety net. It does allow for a 180-day auto extension upon timely filing, starting at the expiration of that OPT EAD card. And hopefully that will buy some time if they have a CAP case, or if generally they are, continuing to work in that under that STEM, they still have that continuing work authorization even without the new card.
And I would also just caution that any students who are completing their degree program who need to file their OPT EAD applications do so at the earliest possible date, which is 90 days prior to the completion date. And because we do anticipate that any EAD application processing times could get longer, even longer than they currently are, which is around 4 to 6 months. And if that happens, there could be a situation where, you need to terminate employment for a student, or, delay the start date until after they receive that OPT EAD. Okay, so impact on business visitors. Obviously with these changes in the travel and restrictions in various countries, which restrict individuals from even returning to their home country, that can have a real impact on individuals who are here as visitors, whether it's for business or for tourism. So there is guidance from CBP that they will allow what's called satisfactory departure for individuals who entered the United States under either ESTA or ESTA visa waiver program. So this is basically individuals who don't need a B visa or B1 or B2 visa to travel to the US as visitors. They can apply for the satisfactory departure in the Seattle area. They will do so at the Seattle CBP Deferred Inspections Office, which is down at Boeing Field. Again, I recommend, if you do have any individuals or know folks in this situation, check with Immigration Counsel how to go about applying for that satisfactory departure, but it will allow them to stay in the US for up to 30 days after that their visa waiver or ESTA period of their I-94 basically expires. And let's see, I think they can apply for it up to 14 days. Is that right? Before
their I-94 expires.
Yeah. Yeah. So does this impact, so if someone's here on a B2 visa, Marcia, do they apply for a satisfactory departure, or they would just file for an extension, right?
Right. So this satisfactory departure is specific to the ESTA program, because individuals that come in under ESTA only receive 90 days. Whereas generally, if you come in through the B1, B2 with a visa stamp, you're given a 6-month allotment, and you have the option to extend it by filing a form with a request to extend it for up to an additional 6 months.
So that's very helpful. And again, like I mentioned earlier, if you have an employee, let's say in H-1B status, who you need to lay off or terminate employment, they could potentially also apply for a change of status from their H-1B to B2 or B1 status. And as long as that application is filed within that 60-day grace period after their last day of employment, they could at least file the application and stay in the US while that application is pending. You can also, that's what you can use that B2 change of status as a bridge to avoid them accruing unlawful presence and being subject to one of those bars that we mentioned that could really impact their ability to return to the US. Okay, so that's the end of our presentation. Thank you very much for joining us. We'll now answer some questions if anyone has. I don't see any questions right now, but if anyone has any, please feel free to post it using the Q&A box. And otherwise, you know, feel free to, again, send us any questions by email, give us a call if you have questions about your employees, workforce, and how to make sure you're supporting your workforce and still in compliance with immigration laws and regulations. We're always available to provide.
I also wanted to put a quick plug in that the attorneys at Ryan Swanson, our colleagues also included, have compiled many additional resources for employers who are affected by COVID-19. And if you visit ryanswansonlaw.com, you can review our practice alerts, which we're really, you know, trying to stay on top of to keep you updated on changes in different areas, including business and bankruptcy, corporate restructuring and employment law, as well as our COVID-19 legal support team, which is a compilation of different attorneys from different practice groups that are staying on top of those issues. We've also listed many federal and local resources for you on that website, and we're happy to help answer any additional questions you might have in these areas.